Okay, so I'm going to go ahead and get started today. Good afternoon. Thank you all for being here to discuss and reflect on New York State's 2020 criminal justice reform legislation, a package of reforms that aim to enhance fairness and equity for all New Yorkers. Today, we'll be focusing on two key aspects of the legislation that have often been overshadowed by the bail reform related foundation of that legislation. Namely, we will be talking about guidelines that establish charges by which law enforcement issue appearance tickets and requirements on the scope, breadth, and timing for prosecutors to share evidence on their cases with the defense, also known as discovery. I'm Jennifer Ferrone. I'm a Deputy Research Director at the CUNY Institute for State and Local Governance, and I'll be your moderator this afternoon. This is the second of a two-part series that CUNY ISLG and John Jay's Data Collaborative for Justice, or DCJ, are hosting to take stock of the reforms 5 years after they began, sharing key insights from research that has been conducted to date on both implementation and impacts, followed by dynamic discussions amongst practitioners that are intimately knowledgeable about the ways in which the legislation has played a role in their day-to-day and on-the-ground operations, policies, and practices. Our last session, hosted in partnership with the CUNY Graduate Center, centered the bail components of the law, while today's session, as noted, will focus specifically on appearance ticket and discovery reform, and will follow a presentation and panel format. You'll first hear from two researchers that have focused on these issues in recent work. First, Kate Jackson, Research Associate at ISLG, will do some context setting by establishing the key parameters of each of the reform areas and speak about implementation successes and challenges based on a process evaluation that ISLG published last year. Her discussion will touch on both topics, but focus more explicitly on the discovery provision. Next, Olive Liu, Associate Director of Research at DCJ, will present data analyses on appearance ticket trends across the state, sharing key similarities and differences between New York City, suburban, and rural jurisdictions, and shedding light on whether the AT provisions in particular have met their intended goals and objectives. At that point, I'll be moderating a panel of criminal legal system practitioners that we have invited here today to discuss key issue challenges and solutions in both of these areas. Today, we want to thank Scott Levy of Forward.us, Youngmi Lee of the Brooklyn Defenders, Tariq Rahman of the Westchester District Attorney's Office, and John Vespucci of John Jay College for being here to participate in the discussion. We are looking forward to a dynamic and engaging panel. Before we begin, I did just want to touch on a few housekeeping items. This is all completely a remote event, so we will be recording it to circulate with other follow-up materials. So I did just want to note that. All presenters and panelists have their bios on our event webpage if you want to learn more about them, along with a multitude of other resources on both of these topics for background and context. The research portion of the conversation specifically will be about 20 to 25 minutes, by which point we will transition to the panel discussion, which will be an additional 45 to 50 minutes, leaving ample time for Q&A from the audience for about 15 to 20 minutes. I did just want to note that if you did have a question, please indicate it in the QA feature of the webinar throughout the event. So I'll be answering them, or the panelists will be answering them at the end of the session, but it's great to sort of collect those throughout so that we could curate them and just see which questions hang together so that we can answer them most efficiently. So I did just want to note that. So I think with that, I'll turn it over to Kate to kick us off.
Thanks, Jen. Okay, I'm just going to share my screen. Okay, so good afternoon, everybody. My name is Kate Jackson. I'm a research associate at CUNY ISLG. As Jen mentioned, I'll first start by outlining the basic appearance ticket and discovery provisions of the reform legislation. I'll next speak about a process evaluation that ISLG conducted, focusing specifically on the ways in which criminal legal system actors across the state implemented the new law. The focus is going to be on key successes and challenges that system actors experienced, which are important to explore to better understand the impacts of the reform in practice, and also whether it met the intended goals. So Bail reform often takes center stage in the discussion, but actually there's a lot in the reform package. So ISLG's original focus of the study was actually on appearance tickets and discovery, though over time, we expanded it to also explore reforms to bail and pretrial services. That webinar was 2 weeks ago, so if you missed it, please be sure to check out that recording. So now I'm going to provide a very high-level overview of the legislation, but should help lay a foundation for understanding the research being presented and also the panel discussion. So regarding appearance tickets, these requirements spoke to the legislation's goal of reducing reliance on detention by providing standardized guidance on appearance tickets. So this is a ticket issued to a person that notes a day and time to return to court for the initial arraignment hearing. It allows a person to wait for that court date in the community instead of spending up to 72 hours in jail, which helps them stay connected to their support systems and jobs and away from the many negative collateral impacts of incarceration. So prior to the legislation, law enforcement officers had a significant amount of discretion when deciding whether to make a custodial arrest or issue an appearance ticket. And the legislation substantially reduced that flexibility by requiring officers to issue appearance tickets for most misdemeanor and e-felony charges, with some limited exceptions like domestic violence charges, a history of failing to appear in court, open warrants, and some others. The reforms also included a time limit on when a person should return back to court for their arraignment, which is now specified at 20 days. So previously, arraignments on appearance tickets would take place weeks or months after their issuance. So for example, in 2019, 75% of appearance tickets issued in New York City were not arraigned till 30 days after issuance. So the reforms reduced the time between issuing a ticket and arraignment. So moving on to discovery laws are standardizing the process of sharing materials and evidence between prosecutors and defenders, including the scope of evidence that must be shared and at which points in the case. So they're a critical part of ensuring that the criminal legal system process is fair, transparent, and efficient, and that both the prosecution and the defense can effectively prepare for trial by accessing the relevant case information. So prior to the reforms, it was not uncommon for defense counsels to receive discovery from the prosecution just before trial would begin, and the defense would have to submit formal requests to receive discovery sooner. So essentially, the discovery laws increased the scope of materials that prosecutors would have to provide to the defense as evidence and expedited the timelines by which they needed to turn it over. So for example, previously prosecutors were only required to provide materials they deemed exculpatory, which is information favorable to the defense. The reforms require them to turn over all material that relates to the subject matter of the case, which, as you can imagine, is much more information than what was required before. They also had to do it much earlier in the pretrial process. The reforms specified that they must share all discoverable materials within 20 days if the individual was detained, although originally it was 15 before that was revised in July 2020, and within 35 days if they're awaiting trial in the community. So if all discoverable materials were not turned over within this timeline, then essentially the case can be at risk of dismissal. So one last important change was that the reforms tied discovery requirements to New York speedy trial laws. So previously, prosecutors could stop the speedy trial clock by stating that they were ready for trial before the defense received all of the discovery, which could ultimately lengthen the time an individual might be detained while awaiting missing discovery. Now the reforms require the prosecution to file readiness with the court, otherwise known as a certificate of compliance, certifying that all discoverable materials have been shared before stopping the speedy trial clock. So again, that's a very high-level overview of the changes to appearance tickets and discovery laws, and hopefully will set up the discussion today. So now moving into our process evaluation. So a key strength of our process evaluation was that it centered the perspectives of those closest to the process and highlighted those on-the-ground experiences of system actors. So we spoke to law enforcement, prosecution, defense, pretrial service providers, and some representatives from the state to understand their experiences in the planning and implementation phases of the reforms. So in total, we completed about 230 interviews by the end of the study in 13 counties across the state and both in and outside of the city. In each agency, we tried to talk to different levels of staff, from leadership to line staff who are working on the ground. So our goal was to ensure a balanced perspective across different system actors. We also analyzed administrative data to supplement our conversations with system actors, conducted a document review, observations of some arraignment hearings, public testimony review, and also a media review. So for the sake of time, I'm just going to jump right into our findings. So conversations with stakeholders centered on the many challenges during implementation, and particularly in regard to the discovery reform. So first, I'll discuss what we learned from our conversations regarding appearance tickets. However, I'm going to spend most of the time discussing discovery reform, as that turned out to be the topic that many of our participants seemed most eager to discuss. So when speaking with practitioners, they reported that expanded appearance ticket issuance required fewer operational changes than other provisions of the legislation, and therefore required less planning. So for example, law enforcement indicated that the process by which they issue appearance tickets didn't really change, and instead simply required appearance tickets to be issued for specific charges. However, one implementation challenge that we did learn from participants, particularly outside of the city, was that the 20-day timeline was a logistical concern because arraignments were not scheduled as often. So this was especially the case for town and village courts, who may only meet something like once per month. So they felt that the reforms were too centered on New York City, which made it difficult to comply with the timelines. Pretrial service providers also expressed similar concerns with the timeline because it made it difficult for individuals to participate in and complete pre-arraignment diversion programs. However, amendments were passed that made an exception for return dates if the person is enrolled in pre-arraignment diversion. Because the implementation wasn't as challenging as other of the provisions of the law, conversations largely centered around impacts on public safety and highlighted the disagreement between law enforcement and public defenders. So officers we spoke to consistently believed that the requirements fully eliminated their discretion regarding arrest practices, and they were concerned that basing decisions on charge would increase crime. They shared scenarios where individuals were issued an appearance ticket multiple times in the span of days, and they had no option but to continue to release the individual back into the community each time with an appearance ticket. Public defenders believe the legislation still left room for discretion given the list of possible exceptions, and didn't see the issue of what they refer to as the revolving door as being as widespread. Amendments to the reforms were passed to address these concerns in 2022, which specified that people arrested for an alleged crime while out on pretrial release could not be issued an appearance ticket, even for a charge that required appearance ticket issuance. And this was among other exceptions that were added. So moving on to discovery. The discovery reforms, on the other hand, were viewed as a sea change that drastically affected how prosecutors and defenders practice and how individuals navigated the plea bargaining process. So both defenders and prosecutors agreed that there was a need for discovery reform. However, they had very different views on the ways the reforms were written and the requirements put in place to achieve its stated goals. So defenders felt that having more information much earlier in the case meant that they were better able to advise their clients about the strength of the case against them, which put them in a stronger position in plea negotiations and helped individuals make more informed decisions about whether to accept plea deals or take the case to trial. So as a result, they reported what they saw as fairer case outcomes for their clients, with more cases they viewed as weak getting dismissed compared to previous laws. And dismissal data collected by the New York State Division of Criminal Justice Services supports their view of higher case dismissal rates post-reform, with 37% dismissals pre-reform in 2019, 41% in 2020, 53% in 2021, and then 48% in 2022. Of course, whether increases in case dismissals was seen as evidence of a more fair process varied across stakeholder groups, so prosecutors we spoke to viewed case dismissals a bit differently. So prosecutors felt, on the other hand, that despite them voicing concerns early, that lawmakers had not considered the practical implications of the changes on their work, as they had the most operational changes that needed to be made in order to comply. First, district attorneys' offices had to create a system for e-discovery for the discovery sharing process, and only had 8 months to develop and get them up and running without funding from the state tied to the legislation. They also now had to be what they called trial ready on 100% of their cases, even if the case would not ultimately go to trial. And this was a huge departure from their previous practice and something they did not believe was possible to comply with. So prosecutors shared that without additional funding or time, they didn't have enough support staff to track down the wide range of materials that were now discoverable for all of their cases, and also legally considered in their possession, even if it was not turned over to them by another agency. And as a result, they reported high rates of turnover during the implementation period, largely due to staff burnout. And as a result, DA's offices that we spoke to had to develop methods to triage cases. For example, only collecting discovery on more serious cases, cases they believed would go to trial, or other considerations offices use to prioritize their cases. Discussions with public defenders confirmed these challenges by sharing that they still were often not getting everything they were entitled to in the required time period. And they also had similar challenges in terms of the volume of discovery. So prosecutors were concerned with the impacts to public safety as well, both in terms of the operational changes and the requirements themselves. So first, the law required prosecutors to share witness contact information with the defense, which they believed reduced witness and victim cooperation and also safety. They saw that fewer would come forward if they knew that their information would be shared. However, case dismissals were the biggest concern that we heard from prosecutors. They shared that even cases with strong evidence suggesting guilt could be dismissed because a single piece of paper was not turned over to the defense, and that such case dismissals would increasingly occur for missing discovery that had no bearing on the case. So many prosecutors we spoke to, therefore, felt that the discovery reforms did not make the process more fair, but instead shifted the unfairness to victims and the broader community, especially since they had less capacity to dedicate time and staff to victim support or alternative to incarceration programs. So in summary, we learned a lot from hearing the perspectives of system actors who were tasked with implementing the reforms, particularly about the challenges of putting complex criminal legal reforms into practice. So that said, now I'm going to pass it over to Olive for her presentation on appearance ticket trends across the state.
Thank you, Kate. As Jen mentioned at the top, DCJ undertook this analysis on desk appearance ticket issuance, warrant issuance for DATs, and other related outcomes, in which we believe is the first or one of the first analyses to look at the statewide impact of New York's DAT reforms. Today, I will highlight findings from 3 key areas. 1, DAT issuance generally and across different New York State regions. 2, whether the reforms affected the efficiency of the courts in processing DATs, and subsequently the need for warrants for failure to appear in court. And 3, whether the reforms impacted existing racial disparities in both DAT issuance and warrants for DATs. Our data come from the New York State Office of Court Administration. They are non-public and include criminal court arraignments in 69 New York State city and district courts in 42 counties. For our analysis, we wanted to try to pinpoint the impact of the reforms independent of other factors. So our sample of cases excludes violations and infractions, the majority of which were already issued DATs pre-reform. We also excluded most cases that can still be denied a DAT because of carve-outs, which I will describe in the next slide. And our standard practice with statewide analyses is to break the state out into 3 geographic regions. So Westchester, Nassau, Suffolk counties as suburban New York City as its own region, and upstate, which comprises the remaining 34 counties. So just briefly on the legislation itself, which Kate has already gone into more detail on pre-reform, police issued DATs to low-level offenses and some nonviolent felonies with discretion. Post-reform, most of that discretion was eliminated. except where carve-outs exist. So the law provides about, I think it's 10 reasons for disqualifying a case or a person from receiving a DAT, even for a misdemeanor. And while most are charge-based and therefore able to be accounted for in our analysis, our data cannot account for the 4 highlighted carve-outs here. And I just want to note that in the following slides, our findings pertain only to the sample of cases where it is mandatory for DATs to be issued without exception, where in cases where these carve-outs do not apply. So overall, DAT issuance increased for all applicable misdemeanors and Class E felonies from 2019 to 2021, before declining universally in 2022. Suburban New York City in blue had high issuance rates, even pre-reform. And upstate courts in orange saw a large increase in the first 2 years of implementation. New York City, on the other hand, which is the green line, continues to have notably low issuance rates, even in the peak year of 2021, so below 50%. And I want to also point to the finding here in bold, which is that based on the rate of increase from 2019 to 2022, we found that we estimate that approximately 20,000 more arrests in 2022 resulted in a DAT. If we take a look at trends over major events and time periods, we find a lot of fluctuation, especially before and after the second quarter of 2020 when COVID hit the state. And I also want to point out that in May of 2022, as Kate has already explained, the reforms were amended to reduce the pool of cases subject to a mandatory DAT. Now, there was a decline in DAT issuance after the amendments were passed, mostly in New York City. But we can see here, if you look at the last 3 bars in each region, that the decline seems to have started earlier, as early as the second half of 2021. And as Kate has already explained, the reforms also mandated a 20-day return provision with a goal of improving the efficiency of processing these mostly low-level cases. And in fact, there was a sizable increase in the percentage of DATs arraigned within 20 days of issuance, especially in New York City and its suburbs. Another aspect of whether the reforms improved efficiency is whether people are more likely to appear at their scheduled arraignment without the need for warrants. And we found that generally, warrant issuance rates were relatively low and stable over the study period in the suburbs and upstate, so the orange and blue lines. In New York City, however, again, the green line there was a consistent increase in warrant issuance from 2020 to 2022. In terms of racial disparities, our analysis points to some positive findings. And I just want to quickly pause here to point out that race data for non-New York City cases were only available starting in 2020, which is why you see 2019 is blank for upstate and the suburbs. So from 2020 to 2022, disparities in DAT issuance shrunk in New York City and the suburbs, while upstate, there was no discernible change in either direction. However, our findings show consistently that Black people were less likely than white people to receive a DAT for the same charges. Although in suburban New York City, the largest disparity was between white and Hispanic people in the middle there. Now, despite the finding that Black New Yorkers are less likely to receive DATs compared to white New Yorkers, Black New Yorkers had the highest warrant rate out of all 3 groups in all regions from 2020 to 2022. And the key takeaways that I want to leave you with are first, that DAT issuance increased post-reform, but not consistently. Second, there appears to be better efficiency of the courts in processing DATs post-reform, perhaps in part to the 20-day return provision. Racial disparities still exist post-reform, but less so in New York City. So some positive findings there. And finally, there's an underlying question in our analysis that came out of our findings around uniformity of compliance and implementation across different jurisdictions and police departments throughout the state that unfortunately our data currently cannot answer. And with that, I will turn it back to Jen.
Great, thank you both. I want to thank both researchers for providing a great foundation to kick off the next part of our discussion. Both DCJ and ISLG have been working since the reform passed in 2019 to really get ahead of, really assessing what has been happening on the ground since that time at the very start. And now it's nice to see, 5 years later that we're seeing sort of what is happening on the ground in data and also, experiences from practitioners themselves. So it's great to see both of our organizations coming together to share that information. I'd like to now invite our panelists to come on, and I will introduce you all. First, we have Scott Levy, Chief Policy Counsel at Forward.us, Youngmi Lee, Legal Director of Criminal Defense Practice at the Brooklyn Defenders, sorry about that. Tariq Rahman, Counsel to the District Attorney from the Westchester's District Attorney's Office, and John Vespucci, Professor and Law Enforcement Consultant from John Jay College of Criminal Justice, though I know has many other affiliations as well. So thank you so much, and thank you for being here today. We're going to kind of focus some questions on appearance tickets, and then we'll move on to discovery-focused questions. Though I first wanted to just really start with a general question and really ask all of the panelists what especially stood out to you as important and or surprising from both of the research presentations that you heard today. And anyone can get started on that question. I'll sort of leave it open.
Sure. So I can speak on behalf of New York City, and I think it ties into why I think New York City has a lower appearance ticket rate than the rest of the state. I think one thing to learn from all of this is that when there was discretion and there wasn't really a mandatory nature, officers were using their discretion to issue appearance tickets. And in New York City, we interchange appearance ticket with desk appearance ticket. And so desk appearance ticket means that someone actually does get handcuffed and taken to the police station. And from there, from the desk, they're given an appearance ticket versus, I think in other parts of the state, appearance ticket was meant to be while you're on the street where the violation or the crime supposedly occurred, the officer gives that person an appearance ticket, and there's not necessarily a handcuffing where that person is taken to the police station. So I think with the introduction of the mandatory nature, the NYPD took that very seriously at face value. We did have a stakeholder meeting. We had a few in 2019 with NYPD, defenders, prosecutors, OCA, Office of Court Administration, about how the new mandatory nature of DATs would occur, including the 20-day return period. There was a question about, well, there are the mandatory DATs, and then there are the mandatory, you cannot give a DAT for certain crimes. And then there are certain factors where you're not eligible, which really means the police officers have discretion, just as they did pre-2020. And the NYPD interpreted that to mean that it wasn't discretionary anymore. So there might be a case where I think out in Suffolk County or Nassau County, a police officer could arrest someone or charge someone with a DWI, but still give them an appearance ticket if somebody could pick them up, even though there might be an interim license suspension. But so in those cases, the officer still had discretion to give an appearance ticket. In New York City, if there was the possibility of an order of protection, a license suspension, if there was a bench warrant in the past 2 years, it seems like it's an automatic no, you can't get an appearance ticket. And so I think that might explain why the numbers went down since 2020.
I mean, while we're on that point, do others that have experience practicing in New York City have other thoughts on sort of this difference that Olive pointed out between New York City and some of the other upstate or suburban jurisdictions that may have experienced different trends with respect to the appearance ticket provisions?
I'm happy to just sort of offer a thought. I mean, the thought that I was going to offer before that question was that the time period that we are looking at here, right, of course, corresponds with the pandemic. And so it is very, very difficult to think about what a baseline means in that context. And I think that sort of just carries over a lot of what we're looking at. I think we are sort of in the process of establishing new baselines. And so the comparisons are always going to be, during this time period, I think, very difficult to say conclusive things about. I should say, so I'm currently at forward.us. I've been here for about 1.5 years. Prior to that, I was a public defender in the Bronx for many, many years. And so I'm largely speaking from my experience there. And I should say, I'm not speaking on behalf of Forward at this panel. I'm just offering my own opinions. But for a few years, I ran a project in the DAT part in the Bronx. And so I was there for months on end and handled and supervised hundreds of cases there. And what you see over time is that cases that come in through the DATs, that what is largely determining the mix of cases and the volume of cases, right, is happening out on the street and is being determined by operations and enforcement priorities from the NYPD. They may shift enforcement from the trains to the sidewalks, right? And that will create a completely different sort of flow of cases into the DAT parts. So I think it is also hard to read too much into the New York City DAT data, because I think it is so largely determined by decisions that are made outside of the system, right? That it has to do with enforcement priorities and allocation of officers in different areas and different priorities responding to different political pressures. And that often is what accounts for swings in what we see in DATs and appearance tickets generally, rather than the application of state law, right? And filtering out certain types of cases. So I would just offer that. I don't have a very specific answer, but that is always my impression when confronted with this type of data, and particularly during this period when I think essentially things stopped, and then we had to sort of reinvent a lot of these systems from the ground up in many ways. And so we're just seeing different patterns play out over time.
Yeah, that makes a lot of sense. And it's definitely a good point about the COVID context. I know when we were looking at implementation and the process evaluation, that certainly came up in the context of appearance tickets in particular, just in trying to make sense of the data and sort of the increase that we saw and then the decrease in 2022. And, I'm definitely needing to connect that to the COVID context and sort of the way that resources were deployed during that time. John, as from a law enforcement perspective and from your experience, I wanted to hear a bit about what you thought were the most common carve-outs that may lead police to potentially at times not issue an appearance ticket when even if people are eligible for it based on the charge.
Great. Thank you for having me here. The carve-outs were essential when it came to this reform, and luckily the state did go ahead and make these exceptions throughout revising these reform mandates, because the officers, especially in suburban areas and upstate New York, or very reluctant to be restricted on not having the ability to address certain carve-outs. When we look at small town policing, the officers do rely largely on informal policing, as well as their sixth sense, as well as knowing their community. So to be able to abide by these carve-outs or have the ability to use these carve-outs in not just domestic violence situations, but other situations within the communities that would help quell disturbances or future violence amongst victims is very important. Property crimes are still limited as far as the carve-out statutes, which in fact is up for another discussion, but the officer's ability to protect the safety of the victim is definitely essential. And the fact that there was reform to allow for these carve-outs definitely, added to the acceptability of the reforms here.
Just for the audience, I wondered if you could lay out what some of those carve-outs were. I mean, even just a few examples.
Okay, carve-outs such as responding to minor crimes that are linked to domestic violence situations. We look at certain minor crimes such as criminal mischief, the intentional destruction of property. Often is not, is considered a non-violent crime. However, when it's conducted within the furtherance of a domestic violence situation, it falls under not only a different classification in the law, but if there's not enough evidence to charge under the domestic violence statute, at least under the criminal mischief provision, the officer would still have the means to bring somebody in for an actual, or have a custodial arrest, I should say, whereas the defendant is brought in and allow for time to draw up or do further research to either extend the possible charges or to seek assistance from a judge or the district attorney in an order of protection.
Great. Thank you for that clarification. I mean, kind of, keeping going with your experience, I wondered what some of the practical issues were in the jurisdictions that you've worked with that either made it easier or more challenging to implement this side of the reform legislation, and sort of where future resources might be focused to improve or enhance implementation.
To preface that question, I think there's some foundational information that's important for the audience and everybody else here to be aware of. When we look at upstate policing or suburban policing, especially in New York, we're looking at a much different demographic. And we're going to address Orange County alone. In Orange County, there's approximately 75 to 80, only 75 to 80 judges, and local courts are very limited. But when we look at the police departments themselves, and I'll talk more about the judges in the courts when we talk about discovery, but when we look into the police departments, nearly half of the police departments have fewer than 10 officers. Okay, and 75% of departments within New York State have less than 24 officers. So when you think about that manpower, when you think about even bringing officers in on overtime, there is a limit to overtime and resources because of exhaustion, as well. So the resources are in fact very limited when we look at some of the practical, issues that arise when it comes to DATs or issuing of appearance tickets. Now, there's been a big benefit within suburban policing as far as requiring police officers, in fact, to use these DATs because it foregoes the custodial arraignment, which was very problematic. The departments often did not have the resources to bring somebody in and hold them for arraignment. In that, most courts in upstate New York do not have full-time judges, like I said. Often, there are judges that are on call during the weekends that might not respond for X amount of time. So the departments often incur the extra costs of watching a defendant or being with a defendant physically until an arraignment is actually able to happen within the court. Keep in mind, again, there is no central booking. There is no facility just to drop somebody off. And the arresting officer is essentially in direct custody and control of a defendant in most departments. There are exceptions from the time of arrest to the time of appearance ticket or arraignment. So when we think about financial costs, when we think about manpower resources, we can see that by the state issuing this directive, it actually has taken somewhat of a burden from manpower within these departments.
Yeah, it's really helpful, and it's really helpful to think about the differences in sort of the court structures and just the way things work outside of the city, which sometimes I know for me working in the city, sometimes I take that for granted. Tarek, I wondered from a prosecutorial viewpoint if you had anything to add on the conversation around appearance tickets.
Yeah, can you hear me okay?
Yep.
Okay, so well, one thing I'd like to point out, one of the carve-outs, right, one of the exceptions to the mandatory is if the subject has failed to appear in court over the last 2 years, right, which I think is important because it shows that the legislature recognized that maybe you don't want to issue a ticket to somebody who has a history of not appearing in court. But practically speaking, there isn't really any way for the officers to know that on the scene. How would they know if this person had failed to appear? That's not something that's readily accessible to the officers. So there's a carve out there that on paper looks like it makes a lot of sense and helps. But there's really no way for the officers to verify that information, on the scene quickly while they're trying to make a decision about whether this is a mandatory appearance ticket or it could be a summary arrest. And playing off of that, one of the things that we had here in Westchester that happened not infrequently is if somebody was arrested, for example, on a criminal possession of a controlled substance in the 7th degree, right? So that would be, used to be discretionary appearance ticket, now mandatory. A lot of times what would happen is if they were actually custodial arrested and they actually made their initial appearance within 24 hours and had an arraignment, we would seize that opportunity to give those people an opportunity for programming right at the beginning. Consult with TASC and other community representatives, see if they could get programming for a defendant at the outset. One of the kind of unforeseen downsides of the mandatory appearance tickets is when you have 20 days before you have to appear, what happens a lot of times is, number one, those people could get rearrested again before they have their appearance, especially if they're suffering from a real substance use disorder. And there's also the potential that they don't show up, right? We're all assuming that they're going to show up on that appearance ticket date. And that's, that doesn't happen all the time. And it's also not a fact that judges will instantly, on the first failed appearance, on an appearance ticket arraignment date, judges aren't issuing bench warrants, right? They're required to give the defendant another opportunity. Depending on which court you're in, judges could give 2, 3, 4 opportunities for a defendant to appear. So, a lot of this in black and white looks like it makes sense, but there are some practical ramifications that could end up actually harming the defendant or not giving them a lot of opportunities they'd otherwise be subjected to. And also the cases suffer, right? From a prosecutor's standpoint, the older the case gets, always, right? The older the case gets, the witnesses start to fall away. You could have a defendant not really appear for the first time for arraignment on an appearance ticket for months after that arrest, not necessarily within that 20 days.
Here for that. We were going to move on to discovery reform aspects of the conversation, but I did just want to leave it a little open at this point to see if there are any final thoughts on just anything that has been said so far from either Scott, Young, me, or John, or even Tarek.
Sure. So I just, I do want to point out that when it comes to the discretionary aspects, some of those factors interweave. So Tarek was pointing out that if someone has a substance use disorder and they have a problem where it's a disorder, that the police officer would still have to give that person an appearance ticket. I mean, Brooklyn has a pre-arraignment diversion program so that people who do get appearance tickets have the opportunity to avoid even having to appear in court if they are offered to do programming. And so they reach out to individuals who might have a court appearance for a desk appearance ticket. And so there are still ways to outreach to people on appearance tickets, and it's actually more efficient because the person actually avoids having to have a whole complaint drawn up and docketed and waiting in court all day. And so, you know, when that officer discretion kicks in, if the officer also believes that this person needs immediate help, maybe they're overdosing, it doesn't have to be an appearance ticket, although the proper route would be obviously to take that person to a hospital. So, you know, there is the 20-day time period. It's not a very long time period. That time period was chosen because in the old days, appearance tickets would sometimes take 2 or 3 months to schedule in terms of an arraignment. And then you would lose that piece of paper that had the court date on it. And that is what then led to warrants. Nowadays, with the 20-day time period, I know that there's less time to maybe complete a pre-arraignment diversion program. But as you said, there are ways to get around that. That 20-day period is pretty good because it keeps the case moving along. People have less opportunity to lose that notice, or they remember it because it's still fresh in their minds. So overall, I know I'm speaking from a defense perspective, but if there is a way to avoid even that whole arrest process going through central booking, which takes more than 24 hours because the courts are so busy, overall for these low-level offenses, the appearance ticket provisions really are helpful all the way around for everyone, for all parties.
Thank you. Any other final thoughts before moving on to the next topic? All right, well, discovery by far received a lot of attention in the interviews that ISLG conducted as part of our work. I know that they may come up less in sort of media accounts of the reform. We hear a lot about the bail aspects, but certainly discovery reform has taken a lot, and there's a lot that goes into it. So we definitely wanted to spend time today talking about that. So I wanted to ask you, Scott, we know that you had been directly involved in drafting of the discovery reform legislation. So I wanted to see if you could take a few minutes and just walk us through that. So, you know, some of the motivations behind why the reform happened, what some of the changes were pre and post reform, and what some of the provisions that you or others wanted that didn't make it into the final legislation, and sort of the process behind that.
Great. So yeah, so the bill, or excuse me, the discovery law that we had prior to 2019 was really the result of legislation that was passed in 1979. So when this discussion was being had about discovery reform, folks had been working with the old discovery law, CPL 240, for about 40 years, and it had been essentially acknowledged as inadequate for 40 years, right? The minute that that law was passed, I think it immediately, you know, was criticized and had been criticized for decades. And so by the time, you know, mid 2000s came along, there was a pretty big movement to make discovery reform happen from all corners of the justice system. And it had sort of hit a number of stumbling blocks over the years. Just to add, you know, for some context, arguably, New York's statute pre-2019 was one of the weakest discovery statutes in the country. It was regularly listed among the bottom 14 states. New York was listed among the bottom 14 states when it came to its discovery law and how you know, much transparency it actually allowed for folks going through the system. And a number of states had adopted broad, transparent discovery laws well before even 1979. But by the time 2019 rolled around, New York was really sort of an increasingly small company when it came to just how bad its discovery law was. And I think one of the major tipping points for New York was that Texas passed in 2014 comprehensive discovery reform. And I think in many ways that sort of shifted the spotlight onto New York and catalyzed a lot of what we saw saw then. So, under the old law, which we heard some of this before in the presentation, there was really very little in terms of what was required to be turned over, and there were no timelines, right? So, if you were practicing as a defense attorney, you kind of got what you got when you got it, right? And that process could drag on for weeks, months, years, right? And in many cases, we had a system, and depending on the jurisdiction and where in the state you were practicing, you either kind of got things in drips and drabs over time. Some jurisdictions, you would get things early, but many jurisdictions practice what became known as sort of, trial by ambush. You wouldn't get discovery until right on the eve of trial, sometimes when jurors were sitting in the box, in the jury box. So you had the system of trial by ambush that led to wrongful convictions. It prevented people sort of accused of crimes and their attorneys from properly investigating and tracking down leads and investigating their cases. It meant that people considering plea offers were doing that without sort of the information they needed to evaluate the strength of the case against them. They were doing it sort of blindfolded. And it gave prosecutors a lot of leverage to sort of extract plea bargains, right, in a vacuum, right, without sort of with an imbalance of information and knowledge on either side. So in 2015, there was the New York State Bar Association convened a task force on discovery reform. And it was really one of these sort of blue ribbon task forces, former judges, academics, prosecutors, defense attorneys, and heavy hitters, folks who had been in the system for a long time, who carried a lot of weight. And the NYSBA sort of task force in 2015 issued a report really calling for the comprehensive overhaul of discovery in New York State. It sort of was premised on having in place protections for witnesses, but also having early, automatic, and open discovery, right? Much broader discovery. And there was broad consensus. And I should note, though, that while there was broad consensus when this report was issued, there were 3 members of the task force who dissented and said that the protections included in that report were for witnesses were not strong enough. So there were 3 dissenters, but by and large, there was broad consensus among the task force that comprehensive reform was needed. One of the things that is unique to New York is the way in which discovery and speedy trial interact. As I think lots of folks on this call will know, New York does not have a true speedy trial law. It has not. We have a prosecutorial readiness rule, CPL 3030. That is unique among all of the states. That structure does not exist really anywhere else. In states that have speedy trial statutes, the statute says a person must be brought to trial within X number of days. New York's law says the prosecutor must be ready for trial within X number of days. And that difference really changes the way that cases move through the system. And what was happening in many jurisdictions, particularly New York City, is that district attorneys would say that they were ready for trial, stopping the clock under 3030, without having turned over any discovery. And in many cases, prosecutors were stating ready for trial at criminal court arraignment, right before a case had even really been assigned to a district attorney. So you had a discovery system that didn't really provide transparency, didn't do it on a timely basis, and also completely undermined and undercut speedy trial protections. So in 2015, this report comes out. That gives the movement for discovery reform some momentum. And the thought was, at that time, Republicans controlled the state Senate, Democrats controlled the state assembly. And the thought was that the sort of blue ribbon panel from NYSBA and that report would catalyze change. That did not really happen. But out of that report came a bill that was introduced in the assembly, which was known as, for many years, the NYSBA bill. And there was an effort to sort of create a consensus around that bill. As we approached 2019, a number of things happened. The Senate Democrats, who were then in the minority, adopted their own discovery reform platform, which was, as I think of it, it was open file discovery, early and broad discovery. They sort of took that position, while the Assembly's position was largely the NYSBA bill. And then, as many folks know, in 2018, control of the state Senate went from Republicans to Democrats, and that dramatically changed the dynamics and sort of what was possible to pass in the legislature. And what you saw from essentially 2018 to 2019, when we ultimately saw passage of comprehensive discovery reform, was a merging of the NYSBA bill, which had a particular structure. It was largely a laundry list of items that would have to be turned over, with lots of very sort of intricate rules about when and how and where, and the Senate bill, which essentially said, turn over everything early unless you have a very good reason not to. That's often how I described that bill. And so what you saw as we came close to, and if folks know New York State politics, lots of big policy decisions and policy happens in the state budget. That's what happened here. What you saw was these bills sort of come together into the statute that we have today. So CPL 245 was in many ways the combination of the NYSBA bill, the Senate proposal that had gone through many, many, many iterations over the years, particularly after 2015 and the NYSBA report. And so that's really, I think, I'm skipping a lot, but that's really how we got the bill and the statute that we have now. The key provisions, as I see them, and I'm sure other folks on this call will have opinions about this, is that the bill, the statute required early, automatic, and broad discovery. And the standard that we heard, sort of matters related to, or materials related to the subject matter, what that really does is take the determination of what is relevant or not relevant to a case out of the hands of prosecutors, and basically says everyone should have access to all of the materials that sort of implicate this case, and does not put the prosecutor in the position of having to be the gatekeeper of relevance, or the judge as the gatekeeper of relevance. There's a presumption of openness as well, right? So the idea is to be incentivize as much transparency as possible. Of course, it created what were called certificates of compliance, which basically required, once discovery had been completed, prosecutors to state that they had done their due diligence and provided all the required discovery. And those certificates of compliance were tied to 30/30 trial readiness, right? So we linked speedy trial and discovery. It also provided for discovery to be provided before someone was taking a plea. So even if full discovery had not been turned over, if prosecutors were offering a plea offer, a plea bargain that would essentially expire after a certain period of time, that people accused of crimes had the ability to see at least a limited portion of the discovery before they had to make that their decision. And it also essentially deemed prosecutors to be in possession of materials that were in possession of law enforcement, which forever and continuing, I think, continues to be a problem, right? That the interaction between law enforcement agencies and prosecutors was for many years, and I think continues to be a point of tension, right, when it comes to the transmission and sharing of information. So I know I've talked a lot there. The final thing I will say is, in my former job, I did a lot of work on court delay and speedy trial, and particularly in the Bronx. And I know that there's always a question of, did discovery cause court delay? In the Bronx in 2015, for a misdemeanor case, the average wait for a bench trial was 688 days, and the average wait for a jury trial for misdemeanor was 897 days. That number is significantly lower now, and court delay in the Bronx has been reduced dramatically for a whole host of reasons. But it has been reduced while discovery reform has been going forward. So I wanted to sort of leave that as well, because the interaction between speedy trial and case length and discovery, I know, is going to be something we talk about here. So I wanted to share that. But I'll pause there, and thank you so much.
Thanks. Thanks for that foundation. And, you know, you kind of talked a lot about sort of how it worked before, how it worked after. Tarek, I wonder from, like a prosecutor's office perspective, why was this such a major shift? Or how did it sort of play out as such a major shift for your office and offices like yours?
So one thing I think is important to talk about for a moment is what happened before 245 was passed under the old rules. I first of all, I completely agree with Scott that the changes were necessary, and I think a lot of the changes are good. And I think most prosecutors agree that most of the changes are in fact good. We do want, of course, to have the defense have as much information as they can have as early on as possible. But I do, before I get into what I think some of the shortcomings of the current legislation is, statute is, it can't be out there that prior to 245, all that DA's offices were turning over was exculpatory material. 240, the old CPL 240, it had a mechanism in place, right? There was not automatic discovery, but the defense would file a motion to produce, or a demand to produce discovery. And it wasn't limited, what they could ask for was not limited to exculpatory. Exculpatory material is turned over, you know, as a matter of course, constitutionally. Brady material, that's got to go over. But that's not all that was going over. A lot of DA's offices prior to reform had open file discovery. You started to see DA's offices being more open to that, you know, throughout the 2000s. You know, it was not the way it was back in the 80s and 90s where DA's offices were really holding discovery close to the vest. You know, obviously there's going to be certain examples of that on specific cases, but I just don't like it out there that the premise that DA's offices were trying to hide the ball from defense attorneys on every case at every turn, and then springing discovery on them when the witnesses were on the stand at trial. I don't think that's accurate. I think that between open file discovery and judges issuing orders requiring the prosecutors to turn over discovery after those demands were filed, lots of material was going over. Not as much as is going over now, right? It certainly is broader now, because now what has to go over is anything that's related to the subject matter of the case. That's really open for interpretation, right? Anything that's open to the related to the subject matter of the case is no longer limited to what's material or what's relevant, right? To Scott's point. And I think that's important, and certainly more material is going over than before. But it also opens up some other issues, right? Now with the time limits, and there's an open question, every ADA has an open question. Have I given over everything that is related to the subject matter of the case? I don't even know if there's something else that's out there, right? What would happen? I'm sure the DAs in the city would talk about, you know, sometimes in the city you could have 15 different officers respond to a scene. The crime has already taken place, it's already calmed down, the subject's already under arrest, but there's multiple officers show up, right? Some of those officers may have written in their memo book that they appeared at this location at this time and written nothing else. Well, that entry arguably is related to the subject matter of the case. The DA has to find and hunt down every single officer, whether it be 5 of them, 20 of them, and often you're not going to know. And you might find out much later when you're reviewing a new body worn camera and you see out in the back corner, oh, there's another, who's that? What officer is that? I didn't have any reports from that officer. And what's kind of stymied a lot of DAs is the fear that I'm going to certify, right? I'm signing my name. I'm certifying that I have provided everything. And I have this fear that I might not be right. And there's this concern about, I'm not signing that certification until I know for sure. And then time is getting eaten. The speedy trial time is getting eaten. There's always a concern that you're going to get in trouble for doing your best and still not doing enough. And there have been some, amendments since the initial passage that have tried to curtail that a little bit. to make ADAs feel more comfortable about filing supplemental certificates of compliance, et cetera. But it does have a major impact. I could go on, and I know there's other questions coming that'll kind of address other things I want to talk about. But I do think that it's important to know that. And look, we can also debate whether there is speedy trial, but I do think that 3030 effectively is a speedy trial statute for us. Certainly, we're seeing cases getting dismissed now because of discovery violations, because certificates of compliance are later getting invalidated, even though DAs, were really doing their best, good faith, due diligent efforts to get all discovery. And they were wrong, right, when they filed their initial certificates. And then as a result, months later, when they find a new piece of paper, cases are being dismissed 3030. So I guess that's just kind of big picture issues.
Thank you. I appreciate that response and sort of foundation. I know that apologies if you hear the sirens in the back. We are in New York City here. I know that the legislation did not provide originally additional funding to support a lot of the changes in the legislation, but particularly discovery reform. And I wondered if either Youngmi and Tariq or even John from a law enforcement perspective can talk a bit about how that could be a compounding issue in carrying some of these changes out, just given that there was a lot of additional technology, resources needed, staffing support, etc. And Youngmi, maybe we could start with you and then move to Tariq and John from there.
Sure. So I absolutely agree that the amount of discovery that we're getting that has to be turned over is tremendous, but the benefit in terms of the work that has to be done in order to ensure fairness, I think clearly outweighs money, resources. I know that prosecutors are afraid of dismissals. On the defense side, we've always been afraid of wrongful convictions. We have always had battles with prosecutors where we would ask for information and prosecutors would say it's not relevant. And for us, it was always, well, it is relevant because it's exculpatory. It may not be necessarily the eyewitness who says he or she did not do it, but it could be information that leads to a more robust investigation, which then leads to exoneration. And I think that's really key. So when we're talking about what's relevant, it's a very sort of evidentiary standard. Whereas if we go to relates to the subject matter of the case, it's more balanced in terms of there has to be an understanding that information out there that is not helpful to the prosecution, but could be helpful for the defense, should also be turned over to the defense. And it's always the police, the arson investigator, the prosecutors who have that information. We don't. We do our own investigation as much as possible. We try to get the surveillance cameras if they're out there. We try to talk to witnesses if we know of them, but usually when a crime occurs, the first people to interview witnesses are the police, sometimes investigators from the prosecutor's office. So we're seeing there's a ton of body-worn camera footage. It's pretty amazing when you see the number of police officers who respond to a scene, the conversations that take place with potential witnesses, as well as with our own clients and what our clients are saying that may not be noticed as statements that will be introduced at trial, but also statements that are very helpful for us. And yes, that's a lot of discovery. So the technology definitely exists. We just need the funding on both sides to ensure that it's all put into one place where the police can put all of their discovery into one place, prosecutors can access it, and then eventually us, so that we can do our work. I mean, we are also on the defense side, and I'm sure prosecutors are doing this also. We're looking for ways to transcribe some of the recordings that we get because there's so much and we need to sort through all of this. But we're also seeing, and I hate to say it, but we're also seeing when we records from NYPD, sometimes it might be as simple as this particular officer where we know there was a bad search and seizure, he or she has been disciplined 2 times, 3 times for failing to turn on their body worn camera, right, during that initial police encounter, which could be so helpful when we're talking about the legality of a stop, search, and seizure. You know, or it could be as extreme as outright misconduct, false reports. And there is a lot of, I hate to say it, a lot of instances of misconduct when the police are the main witness, whether it's a hearing or at the trial. So there's a lot more than we expected. And there's even discovery that we get that I'm sure ADAs didn't even know existed. So I think it's pretty eye-opening for both sides. And when I say both sides, I mean the prosecution and the defense. So funding is important.
Great, thank you. I just, oh, go ahead, Tarek, were you gonna jump in?
Question, that's fine. I was just gonna answer your first question about the funding, but
Yeah, no, go ahead. And then I'd like to hear from John about what like law enforcement would need to support getting those materials to prosecutors to be, you know, what mechanisms would be helpful in that.
yeah. So I agree completely with what Young Mi is saying about, you know, it's crucial that this information go over, right? So if I left the impression that I thought we should go back to a relevant material standard, I do not agree with that. I think that the issues really are more about the time frame, right? Because they are such tight time frames, and it dovetails into your question about funding, right? There's no funding for this. There was no funding from the state. The state passed it, but they didn't give any funding. And you have kind of a confluence of different issues. You've got already a decreased size of the pool of graduates from law schools that were interested in being prosecutors in the first place. And then you add to that the job really fundamentally changed with the passage of the law, because the job became much more ministerial in the front end, and ADA is spending a lot more time hunting, gathering, trying to find discovery in those short time frames than they were doing before. And it just becomes really not a very enticing job. And what we're trying to do is trying to find ways to deal with that by creating discovery bureaus, discovery units within DA's offices, which require, you still have to have ADAs, right? You got to have dedicated ADAs that can supervise those units. So that's more people, which means more money. You also need to train paralegals, right? A lot of this work can be done by paralegals that are trained and help hunt for that paper, right? And I know John will talk about the police end of it, but you know, we need to get the information from the police department. So a lot of times the police departments think they gave us the information and there's something missing, right? So you got to pick up the phone. Someone has to be on the phone, in email, following up. I think I'm missing this, I think I'm missing that. Now, with the NYPD, even though there's so many different units, right, at least you have a common sense if you're a DA in the city about, here's the type of documents I should expect. So here's what I know to look for. Here's what I know is missing. Here in Westchester, we deal with 42 different police departments. Every single one of them does everything completely different. They have different reports, different terms, different names for everything, whether they keep it, don't keep it, have it, don't have it. You got to figure that out. Every single case is going to be different, right? So trying to get that paper, know what's out there, know what's missing, it's complicated. And I think, you know, a lot of the other upstate offices would probably say the same thing, that there's no one monolith. So, you know, I just go to the NYPD and I get everything. It's not as easy in other offices to get that material, which is why it takes more time. And then without funding, you know, it's just hard. It's hard to convince people to stay. Attrition is huge. I think discovery reform had an impact on attrition. I'm sure you've all read the articles about how many ADAs are fleeing DA's offices throughout the state. It's hard to keep people and it's hard to attract people. And just really quickly, the technology, right? I think Young Mi is right. Technology is a great way to help address these issues. But again, it's astounding how much money it costs. The storage costs, every case now has body worn, not every case, but many, and hopefully soon all. cases have body worn, the amount of money it takes to store that amount of body worn camera footage, we have to store it, because if we put it up on a link and the defense attorney didn't get it, or didn't open their link, or couldn't get the link, or the link expired before they had a chance to view it, we can't just delete it. So we're retaining all the body worn camera footage for every case that we have, basically forever. And you think about the expense, and then it costs money to access, to go back into the archive and pull it out. Every time you play body worn camera from the storage, the DA's office is getting charged for that. So the amount of money that we're expending to just have it on hand and then be allowed to view it and allow defense attorneys to view it is astounding. And the governor has done a great job of trying to get us money, but it's not enough. More money is needed to be able to allow discovery reform to really be doable for DA's offices.
John, from the law enforcement side of things, yeah, what is needed? Because I know a lot hinges on gathering those materials and getting them over as well.
Well, I just want to expand on my two colleagues here and address just two or three issues that they brought up. And starting with the last, yes, money is definitely a major concern. These discovery reforms, agreeably, were definitely needed within New York. However, the extent to which these reforms were passed and the process in which they were passed did not provide for the funding to which local and smaller police departments, who might be operating on a considerably less budget, as well as a much less of a tax base, have really suffered in part because of the necessity for discovery. Now, more importantly, and at utmost important, the most important principle, the idea to abide by discovery laws and be all inclusive in discovery material is a tenet of policing. To be able to afford justice for a victim, is paramount. And the fear is always within the back of every officer is that, has all the discovery been turned over, and is the case complete, where a technicality will not have the case either thrown out or inappropriate prosecution due to it. Now, it is largely the also concept that not knowing exactly what is included within discovery, even though, yes, there is a defined list, but do things always come up? Is there another camera that is, noticed, or another interaction, or another officer that had jotted something down that might be considered Rosario that the discovery unit does not know about? Absolutely. In performing the discovery or abiding by the discovery requirements, in smaller departments, the officers themselves, in closing a case, has expanded that case time dramatically. When I say closing a case, I'm referring to essentially the arrest and the preparing of all of the information needed to turn over to prosecution. Traditionally speaking, an officer could make, and just to use a simple petty larceny arrest as an example, can make an arrest based upon an affidavit and a deposition with a supporting deposition, and go ahead and process, say, a petty larceny arrest. Now that officer must wait for a copy of the video from the store itself, any video from the parking lot, that showed the defendant leaving the location, as well as many other associated requirements under discovery. Now, that might take, or that often actually does take, an officer from maybe a 30-minute to an hour call for service running into, maybe 2 hours or more. So does it take officers off the road? It absolutely does. Now, when it comes to processing this discovery, there are many departments that do not have the manpower or the even clerical staff that often is used to process discovery items. Also, as we see, a lot of departments' clerical staffs are on a part-time basis. So when we have July 4th weekend, Memorial Day, New Year's, or certain events throughout the year, where it is more common to have a higher amount of arrests, people need to be called in on overtime just to process the discovery, because again, it has to be all compiled within that typical 20-day time frame. So it does create a personnel imbalance, and often, resulting in either overtime or officers being taken off the road, which are often not replaced due to the fact of a lot of lack of availability to backfill patrol.
Great, thank you. Yeah, it's I know when I kind of came into this content area, I was kind of thinking about discovery reform with respect to defense and prosecution, and sort of learned a lot along the way around the law enforcement ramifications as well. So that was really helpful to lay out. I'm cognizant of time because I do want to get to audience questions, though I know we had a slightly late start. So I want to ask two quick questions before we kind of move on to that. So we might go slightly over if that's okay. But around the timeline piece, I just wanted to know, and anyone can answer this, but from your experiences, are DAs generally completing discovery within those timelines? The 20 days for people detained or 35 for those released before trial? Because I was just curious that when that doesn't happen, I mean, you all talked a lot about some of the reasons for delay, but I'm just wondering on a general level if we're seeing those timelines being adhered to.
So from a Brooklyn standpoint, and I think it's also true throughout the city because I talked to other city defenders, the 20 or 35-day timelines are not being met. I think on some of the felonies, we get discovery in stages. As the DA gets discovery, they'll turn it over. On the misdemeanor cases, I feel like DAs will wait to see if they can actually prosecute the case, which kind of tells you also that maybe there shouldn't be so many arrests in the first place. And then when they get the cooperation of a complaining witness, they will then start turning over discovery, but it's usually pretty late. And it seems like they have to go searching for it in different places as opposed to having everything ready to go when they're ready to actually announce ready. So they're not really complying with the 20 or 35-day time periods at all, which is also does not work in our favor from the defense perspective, because we would like to also start investigating as early as possible, because we represent people who are in jail and might be needlessly so in jail. So it's a problem for us, not just from, oh, we're going to get a dismissal 90 days later on a misdemeanor. It's not necessarily about that, but it also hampers us and brings us back to Article 240, pre-2019 discovery laws.
Are there any final thoughts on discovery that you all just wanted to make sure were entered into the conversation before we move to questions? Because I just want to make sure that everyone did have a chance to kind of say the key points that they wanted to make sure were important.
Well, there's one thing I'd like to just add is that, the coupling of 245 to 3030, I think in some ways is problematic. To me, it was two steps that were taken at once to come up with stricter timelines and broader discovery that needs to be turned over, and certificates of compliance having ADAs have to sign certifying that they did do and have provided all the discovery as required. There are sanctions and there are remedies if there's belated discovery or if there is a failure, some shortcoming to that. If you don't turn over the discovery, as young me is saying, in the time required by the statute, including reopening hearings or even preclusion, right? You get really important evidence. You have a discovery of some DNA that you didn't know was taken, you didn't know existed. It gets tested. It's helpful to the prosecution, but it wasn't turned over in a timely manner. That gets precluded, right? So there are ramifications to not following the statutory timelines, despite best efforts, right? I'm always talking from the perspective of the ADAs that are actually trying, right? The people, the efforts, good faith, due diligent efforts that are being made, and having the additional possibility, likelihood even, that a case will be dismissed and how that impacts victims, right? So you have victims who are basically being punished, having their cases dismissed because a prosecutor wasn't aware of and thereby not able to get their hand on a report or a couple pieces of paper that were effectively duplicative, or even if not, right, these other remedies I'm talking about could account for that failure, something short of dismissing the case. And I think that's, should be part of the conversation, that the decoupling is something that I think should still be discussed, even though I don't see it happening.
If I can jump in, I think one of the things that really sort of overshadowed the conversation when these bills, when the statute was being written, is what interests 3030 and discovery are actually protecting, right? So discovery says that if you are being prosecuted by the state or the government, you have a right to have that prosecution happen with a certain amount of time, because the mere fact of having a case hanging over your head is detrimental to you, your family, your standing in the community, right? So speedy trial really protects those interests, and it doesn't ask why there was a delay. It just says that the government has a certain amount of time to bring your case to trial, right? And I think what the statute we have recognizes is that in order to bring a case to trial, you have to have provided all of the necessary evidence and discovery in advance, right? That you can't stop the clock when not everything that has been required has been turned over, because then what that does is put the burden back on the person who stands accused of the crime and puts them having to sort of bear the prejudice of having delay and a lack of a speedy trial. So I think making sure that keeping those things sort of in mind is really critical, because what often happened in the old sort of regime is if, the evidence that was very helpful to the prosecution, that was usually turned over quickly. It was often the stuff that was helpful to the defense or that was sort of deemed by prosecutors to be neither, irrelevant or not material. That stuff gets later. And so the reason that sanctions in that system don't work is because preclusion was rarely used. The sanction that is often given is giving the defense more time to review the materials that were belatedly turned over, right? More time is actually exacerbating the prejudice, right, to the person who is being prosecuted, right? Because who has an interest in a speedy trial, right? So the sanction was often not a sanction for prosecution, but was actually a sanction for the defense because it further delayed the case. It pushed things back, right? And so I think that the linking of speedy trial and discovery was, and you can see where that tension lies, right? But that was why it was so very important, because often in the old regime, delay just begat more delay, right? Something was turned over late, and then there had to be additional delay in the case so that the defense could sort of absorb it and take it in, right? Which didn't actually prejudice prosecution in any way, but prejudices the sort of speedy trial interest of people, facing crime. And then the final thing I will also just say is, what I think also is part of the statute is that what prosecutors are saying to courts when they file their certificates of compliance is that they've conducted due diligence, right? And that we just had a court of appeals case that made that very clear, that the standard is due diligence, right? And so I think what you're hearing too is like the difficulty, then sort of the logistical complication of saying what due diligence means, right? When you have a large volume of discovery that may need to be turned over. But the standard is not absolute. The standard is actually due diligence. And I think and we heard from Young Mi and everyone on the panel that funding is really, critical for that, to make sure that there are systems in place so that people can do their due diligence.
Yeah, oh, go ahead. I'm sorry.
I was going to move to the question, but if you have a quick concluding thought, I would love to hear that. Yes.
Just wanted to point out that the Article 245 has sanctions, and you go from the least extreme, which is an adjournment, all the way to a dismissal and everything in between. And judges will utilize the adjournment to avoid the dismissal. And so it's not a real sanction when we get late discovery. It just means people will sit in jail for 2 years. Due diligence, as Scott pointed out, is a standard that has been around forever under pre-existing 3030 amendments. So prosecutors are very familiar with it. It's something that the Court of Appeals in Bay talked about. And it's a loose fact-based standard that judges can use just in terms of what are the DAs really doing to get that discovery. It's not sort of an automatic dismissal if it's not turned over. DAs just need to show that they engaged in some kind of inquiry to get that missing discovery. And we have lost plenty of 3030 dismissal motions where DAs have shown that they engaged in due diligence. And that's just an example of why due diligence works, because it's been around since the existence of CPL 3030.
That's really helpful. And, you know, there's so much to unpack here. I mean, some of the audience members do have questions, you know, related to discovery. So I think I'll just continue that thread because some of their questions may actually get into other areas that you all may have wanted to touch on. So I appreciate you sticking with us, and I'll go through quick because I know we're already slightly over. But we have one question. I want to make sure that I frame this right, so I'm just going to read it here. But it says, regarding Tarek's point about the ADAs needing to turn over everything when there might be material out there in these cases where tons of officers are on the scene, do you believe that the burden there should fall on the statute to be amended to be more lax on these discovery requirements, as opposed to police reducing the number of officers they may be sending to the scene on calls? Or to phrase differently, wouldn't it fall on the police to revise the way they're deploying large number of officers instead of on the law to reduce the rights that the law is aimed at protecting?
Is that for me?
Yeah, I would say so, because it was connected to your point there.
Yeah. To me, it's more about the timing, right? Again, if we don't want to have a statute that is impossible to comply with. So it's not that the police should be sending less people to the scene. The police should send as many people to a scene as they think is appropriate. And it's not that that material shouldn't be gathered and turned over. But there is a complication of trying to make sure you know that you have actually got your hands on everything. And it does freeze ADAs. You know, they get frozen in their tracks of, I'm afraid to say that I've turned everything over because I don't know that I have. And I think that you get these balancing act of, I want to comply. I want to turn this over within 20 days. And I also want to certify that I've turned everything over within 20 days. But I also don't know that I have, because it's only been 20 days and I haven't gotten this phone call back, and I have I got a whole stack of cases that I'm trying to deal with, right? Because we know that attrition, there are less ADAs working in every office. So that means there's more cases for every ADA. And I've got all these burdens weighing on me, and I'm trying to do the right thing. And I just think that the time frame is too tight if we want people to comply with those timeframes, right? And someone did touch upon this. You know, when the statute was first passed, it was 15 days, irrespective of whether they were in or out. And I think it's good that they've expanded that. But I still think those timeframes are really tight. And it's not an argument that we should give over less or try or not. Oh, we don't have to find out that what's going on with that one cop, because that cop may have something relevant or important to the defense, or as young me pointed out, maybe they don't have anything, but they can lead to something else. That's all good, and that should all go over. But it puts ADAs in a really difficult spot to say you got to do it in 20 days.
Yeah, thank you for clarifying that point. I think that was helpful. Another question that came in was whether there are any opportunities for cost sharing for e-discovery outside of New York City.
We've definitely talked about it. You know, in Westchester, we've had conversations with Legal Aid Society and trying to figure out ways to do that. But a lot of it gets very complicated with who controls the budgets, and it's not as if the DA's office has its own money that it can just do whatever it wants with. There's a complication with having to get approvals from the county, and every county operates differently. So it's complicated, is how I would answer that.
There's another question that came in around sort of the points that Scott ended on. So it says it sounds like coupling is the main issue, but that streamlined turnover of evidence. Sorry, let me just read through it. It sounds like coupling is the main issue, but that streamlined turnover of evidence as things are gathered. Is the solution really decoupling, which would, like Scott is getting at, violate the right to speedy trial, especially if they're sitting at Rikers in the meantime? Or is it better and more streamlined or is it a better and more streamlined process of turnover from police and investigators to the ADA so that they don't have things coming up at last minute and then are excluded, et cetera? So it sounds like I'm trying to sort of, I was reading the words as they were gathered, but is it better or more streamlined? Is it a better and more streamlined process of turnover from police and investigators to the ADA so that they don't have things coming up at the last minute that then are excluded? Does that help clarify?
So
No,
I,
it
from a
helps.
perspective, just in terms of streamlining, I have to say that I would think prosecutors and the police would not want defense attorneys to just go into a shared discovery portal, because we have had cases where the DA say we need to get a protective order. And so on the more serious cases, the ADAs are looking through their discovery and they're reaching out to us and saying, we want to redact some information, or we want it to be for attorney's eyes only. And so, so there is that gatekeeping that does happen with prosecutors, but I don't see why the police and the prosecutors cannot just have one discovery portal. And I say this reading the news articles about Detective Scarcella.
Any other thoughts on that question? So I think I'll just maybe do one more question on discovery here, but are there instances of prosecutors' offices being penalized in some way for failing to comply with discovery laws, or is the remedy typically only dismissal?
So we've also had cases where we've actually started a trial and the DA says, oops, I forgot that there were an additional 30 pages of DD5s. It happens. And it might be because there's a failure to communicate between the prosecutor and the police. I think that's usually the reason. The remedy is not a 30-30 dismissal, because a 30-30 decision has to be made prior to the start of trial. And so that's when we get into the land of sanctions. And as Scott said, even with these serious discovery violations after a trial has started, judges will not penalize either the prosecutor or the police by dismissing the case. They might say, okay, we'll reopen the hearing, which we don't really have time to do that. Or they'll just say, I'll give you 1 or 2 additional days to review all of the discovery. So so it's not, you know, I don't call a 30-30 dismissal a penalty. I wouldn't characterize it that way. It's much more of, this is the consequence for, I hate to say it, failure to exercise due diligence.
And there was a question that came in, but I'm not sure we have data on it at the moment. We could likely take a look, because I know we have it in a few different forms, but they asked how many cases are in fact dismissed due to 30-30. I don't know if anyone sort of in their jurisdictions might, or even whether that has increased since this legislation took effect.
It's definitely increased in Westchester, the amount of cases that are being dismissed 30-30. Just asking around, so I don't have stats on that, but I can say anecdotally that everybody agrees that the number of 30-30 motions and the number of dismissals has increased since 245.
So in New York City, the data was very faulty, and there were a lot of dismissals that were actually 30-30, but they weren't reported as 30-30 dismissals. So I think everyone here knows that you can get a 30-30 dismissal that has nothing to do with discovery compliance. It could be that the case was facially insufficient. It could be that the supporting deposition was never filed. It could be that the DA just wasn't ready for trial on 5 adjournment dates. And so there were plenty of 30-30 dismissals on other grounds. And then there were times when the DAs knew that they were going to hit the 30-30 deadline, but they didn't want to call it a 30-30 dismissal, so they would say interest of justice. And so the data was very flawed. And so it's difficult to do a comparison in terms of, is there an extraordinary number of 30-30 dismissals now? Yes, because in the spring of 2023, OCA and the DAs agreed that if the real reason was a 30-30 dismissal, they would say that it was a 30-30 dismissal. And then, of course, within that bucket of 30-30 dismissals, you have to extract the discovery violations. And sometimes they go hand in hand with the inability to get a corroborating affidavit because they can be very close together. So it's really hard to get accurate data in that area. But I mean, we do get 30-30 dismissals because of discovery violations. I would not characterize it as extraordinary.
Yeah, that's helpful. And I do know, as a researcher that yes, we've had trouble sort of narrowing in on those because there's not a lot of there's not a lot of valid, information available on the specific reasons. Well, I mean, I want to thank you all for a really engaging panel. I know that this was, one of our more technical panels, though we got a lot of substantive information and I'm sure we could go on forever about this topic again, I think overshadowed, but certainly very important to the conversation. I just want to end with a very quick, one word, if you want anyone to take something away from this discussion, and even the researchers, I'd love you to pop back on and just give one, lesson learned from this conversation. Then I think we can end today, but I just want to thank you all. This has been really a great discussion. So Scott, I'll popcorn you first.
I am just hopeful, right, that eventually that this law and all the laws we've been discussing, right, can really sort of find their way to be sort of settled and sort of actualized, because I do think the ultimate aim was to make the system just fundamentally fairer, right, and that is the aim I think that we should all be sort of looking toward. And so that's maybe not the most helpful final word, but that's sort of where I am.
I agree with Scott. I was going to say something very similar, which is that implementation takes time. And we're all learning about the laws. We're all learning about the discovery that's out there and how useful it is for everyone. And it also obviously requires the technology. I mean, that's very clear. So I'm just hoping that with time, we'll see how great Article 245 is.
For John, do you have anything to offer?
Just to add that, reform is not an absolute. Then this concept of continuing to evaluate and reevaluate measures to make our system better. And, as having forums like this and sharing information, especially from various different stakeholders and researchers, I think it's very much important that we see that we can go ahead and continue to challenge ourselves in revising and reevaluating the laws put in place, for the good of society.
I'll just say thank you for allowing the prosecutor perspective. I really appreciate the opportunity to speak on it.
For Kate, from a research standpoint, do you want to conclude us?
Sure. I mean, I think, this just kind of lends itself to the view that, it's important to do research on implementation, obviously, and particularly, I think, qualitative work, speaking to different stakeholders on the ground, to contextualize a lot of the data that we're seeing, especially because there's limitations on that data. I learned an incredible amount that I didn't know about the discovery process by having these conversations with prosecutors, defenders, law enforcement, that I think you don't get from focusing just on impact. So I think it just shows how important that is to have these conversations, to understand, the incredible amounts of nuance that that happen when you look at the reforms on the ground.
And I just want to kind of end by reminding the audience about DATs again, just to bring it back to DATs, because we've talked a lot about discovery, which is great. But DATs, I guess the reforms are much more straightforward than other aspects of the larger reform package. But at the same time, I think it's important for everyone, I think researchers, policymakers, practitioners, and just the public to be more educated about what DATs are, how the reforms impact the practices that are going on right now, because it does impact a lot of people, probably far more than any other piece of law does. And so, yeah, I just wanted to bring that front of mind again, and thank you.
Thank you for looping back, and thank you all for your time. Thank you for allowing us to stay extra time today as well, and have a great rest of the day. I appreciate it.
Thank you.
Bye.